it is important to understand that in terms of discretion, there is a large difference between that of the president and the governor of the state. We can argue, or we can say that the governor of the state has certain aspects wherein he enjoys discretionary powers which is not even available to the president. So this is even codified under the constitutional provision which says that the governor of the state is expected to act on the aid and advice of the chief minister and the council of minister in all matters other than those matters wherein he is required to exercise his own discretion. So discretionary powers is codified within a part of the constitutional framework concerning the governor position. So what are these aspects, and what are the cases in which the constitution expects the governor to exercise his discretion? So when we say discretion, it means in these matters the governor is expected to act independently and he is not bound by the advice or the suggestions that are given by the chief minister and council of ministers. So number one is a case wherein the governor of the state reserves a bill for the consideration of the president. In certain cases, when a bill is mooted by the state legislature, the governor, rather than giving his assent, is entitled to reserve the bill for the consent or the assent or the consideration of the president. So in this matter, he is expected to act in a discretionary manner as per his own personal discretion. Number two, in respect of recommendation of imposition of president's rule in the state. So particularly in the context of cases wherein the law and order within a state is subjected to a collapse, or the government in a state is not being carried out in accordance with constitutional norms and principles, or where there is a failure of constitutional machinery in a state, the governor can recommend the imposition of president's rule as well as the suspension or the dismissal of the state government. So in these cases, the governor is expected to act independently and he is not expected to act as per the aid and advice of the chief minister or the council and the council of ministers, who would inevitably advise him not to do so. So that is an important matter wherein he acts as a link between the central government in order to know the ground realities of the state. Number three, while exercising his functions as an administrator of an adjoining union territory. So when we speak of the position of that of a lieutenant governor or that of an administrator, in most of the union territory that has an administrator, the administrator in those regions has broader or larger discretionary powers than that of a governor. So in all those cases, he is entitled to act as per his discretion. Moving ahead, what are the other places wherein he is expected to act in a discretionary manner? In the matter of determining the amount payable by the government of Assam, Meghalaya, Tripura and Mizoram to the autonomous tribal councils that exist therein as royalty for licenses for mineral exploration. The constitution envisages a special scheme for these tribal areas of the northeast in respect to the sharing of resources and mineral wealth, and also the sharing of monetary wealth in exchange for the exploitation of these resources, right? So in order to do that, the amount of compensation that is to be paid to the tribal councils, which comprises of the indigenous population, that is expected to be determined by the governor of the state, and this is a power that is acted in a manner as per the discretion of the governor and not as per the aid and advice of the chief minister. Next comes the aspect of seeking information. Similar to that of the president, we can see that the governor of the state is entitled to seek information through the chief minister in respect to the functioning of the council of ministers and in respect of policy proposals that may be therein. So broadly speaking, these are the powers and functions of the governor of the state and those matters wherein he can exercise discretionary powers. So moving ahead, we are by and large done with the position of the governor and his powers, functions, roles and responsibilities. We will be moving ahead to discuss the Chief Minister and the Council of Ministers. Begin Chief Minister and the Council of Ministers, I urge the students to revisit our module pertaining to the Prime Minister and the Council of Ministers so that you can better understand the similarities and differences that exist between the both. So similar to that of a governor, we can categorically say that on several levels, the position of the Chief Minister and Council of Ministers is running parallelly to that of the Prime Minister and the Union Council of Ministers. The state executive in India is also inspired by the British Westminster style of government, with both a head of the state government as well as the head of the government. So that is, the head of the state executive is the governor, who is the nominal or de jure executive. On the other hand, we have the head of the state government, that is the Chief Minister, who is enjoying the actual, real, de facto powers of the executive. When we look at the constitutional provisions pertaining to the Chief Minister and the Council of Ministers, under Article 163 to 167, we can deal with the provisions. What are the provisions pertaining to the Chief Minister and the Council of Ministers? Article 163, which runs parallel to Article 74, talks about the Council of Ministers to aid and advise the governor. 164, which talks about other provisions as to ministers. 165, which talks about Advocate General of the state. 166, which talks about conduct of business of a government for state, and 167, which talks about duties of the Chief Minister in respect of furnishing information to the governor, etc. So broadly speaking, as we've already discussed, the position of the Chief Minister in terms of his appointment is the same as that of the Prime Minister. In the state level, it is the governor who appoints the Chief Minister, and similarly there is no specific constitutional procedure that is specified, and as per constitutional convention, it is the leader of the majority party within the state legislative assembly who is appointed as the Chief Minister. And in case where there is no clear majority, the discretion of the governor is invoked, and he may choose the leader of the largest party or coalition within the state level, who may be required to prove their majority through securing a vote of confidence within a reasonable time frame. And similarly, the Chief Minister at the state level can be a member of either house. Predominantly speaking, most of the state legislatures comprise of a sort of a unicameral system, wherein there is a single wing of the legislature comprising of the state legislative assembly. However, there may be in certain states a bicameral form of government, wherein there may be both a state legislative assembly as well as a state legislative council. So constitutionally speaking, the Chief Minister can be a member of the state legislative assembly or the state legislative council in those states where it is bicameral in nature. But predominantly across India, most of the Chief Ministers are coming out of the state legislative assemblies only. Moving ahead, what is the tenure of the Chief Minister? Similar to that of the Prime Minister, the tenure or the term of the Chief Minister is not fixed, and he holds office during the pleasure of the governor. And it means that it is not the personal pleasure of the governor, and a person who is a Chief Minister who has the majority support of the state legislative assembly, he cannot be dismissed by the governor. However, a Chief Minister who has lost the support of the majority of the state legislature is expected to resign, failing which he will be dismissed by the governor. And similar to that of the Prime Minister, the Chief Minister's position can become vacant by his death, by his resignation, or by his dismissal by the governor. Subsequently, when we look at the functions of the Chief Minister, it is similar to that of the Prime Minister as well. All members of the Council of Ministers are appointed by the governor at the behest of the chief minister. He allocates and reshuffles the portfolios amongst the ministers as per his convenience, which is further done by the chief minister at the the governor at the behest of the chief minister. Moving ahead, he also presides over the meeting of the Council of Ministers at the state level and influences its decisions. He serves as a guide, directs and controls and coordinates the activities of all ministers at the state level. And upon his resignation, upon the resignation of the Chief Minister, the Council of Ministers within the state collapses. When we speak of the position of the Chief Minister in terms of his functioning and his linkage with that of the governor, it is important to note that he is the principal channel of communication between the governor and the Council of Ministers. It is the duty of the Chief Minister to communicate all decisions of the Council of Ministers to the governor, to furnish information when required to do so by the governor, and also to submit specific matters pertaining to policy consideration at the behest of the governor before the entirety of the Council of Ministers. Parallelly, he also advises the governor in the appointment of positions and offices such as the Advocate General of the state, the chairman and the members of the State Public Service Commission, as well as the State Election Commission and various such other bodies at the state level. When we look at the State Council of Ministers, once again the constitutional provisions are found under Article 163, which talks about the position of the State Council of Ministers, their appointment, tenure, responsibilities, qualifications, oaths, salaries and allowances are provided under Article 164. Moving ahead, we also have provisions pertaining to appointment of a member or a person as a minister in the State Council of Ministers who is neither a member of the State Legislative Assembly or the State Legislative Council, with the condition that within a 6-month time frame he gets himself elected or nominated as an MLA within the 6-month period. And similarly, even at the State Council of Ministers level, there is a right upon the State Council of Ministers to take part in proceedings of either house if it is bicameral in nature, but voting rights are limited to the original house from which a minister was elected as a member of the Legislative Assembly or the Council. This is provided under Article 177 of the Constitution, and this runs parallel to Article 88 of the Constitution, which says that the Union Council of Ministers are free to move across the Houses of Parliament. Proceeding ahead, what is the function and composition of the State Council of Ministers? So we can clearly see that under Article 163, it provides that the Chief Minister and the Council of Ministers shall advise the governor, and the advice rendered by the ministers shall not be enquired by the court. This is only in respect of matters which are not subject to the discretionary powers of the governor. So what it means is that there lies an arc or a range of functions or powers of the governor which he exercises independently without the interference of the Chief Minister and the Council of Ministers. And apart from that, Article 164 Clause 1 lays down the rules and regulation pertaining to appointment of other ministers in the State Council of Ministers. There is an additional important principle which mandates that in particular states such as Madhya Pradesh, Odisha, Chhattisgarh and Jharkhand, it is mandatory that the governor at the behest of the Chief Minister appoint a separate minister for tribal welfare. So proceeding ahead, we have Article 164 Clause 1, which also talks about the pleasure of the governor, which codifies the principle of doctrine of pleasure at the state executive level. And apart from this, we have the ceiling limit in the form of threshold on the maximum size of the State Council of Ministers, insofar as it cannot exceed 15% of the total strength of the state legislative assembly. However, there is also an additional caveat that in no case will the size of the chief ministers and the council of ministers fall below the threshold of 12. So even in small states wherein the total composition of the members of the state legislative assembly is quite limited, the size of the chief minister and the council of ministers is expected to be a minimum of 12. So in no circumstance is it allowed to fall below this threshold limit of 12, particularly in those states which have a small sized legislative assembly. In addition to that, the provisions pertaining to anti-defection law, which are applicable at the central level, are also applicable to the position of a minister. The concept of collective responsibility is also codified. Oath of office and secrecy in the case of the ministers of the state is administered by the governor, and in case of non-members, them being appointed, they are expected to get themselves nominated within a time frame of 6 months. And salaries and allowances of the state ministers are also empowered to be decided by the state themselves. So the state legislative assembly is free to determine the salaries, allowances and emoluments of the state ministers. So which is why we see that there is a digression, there is a difference in both the salaries of MLAs across the various states of India, as well as the salaries, emoluments and benefits that are enjoyed by the ministers across the various states that there exists in India. Proceeding ahead, when we speak of the responsibility of the state ministers in the state council of ministers, the principle of collective responsibility, the principle of swimming together or sinking together exists, and a decision at the state cabinet level is binding upon the entirety of the council of ministers at the state level. And if he does not agree to a particular decision and he is in strong disagreement, a particular minister is expected to resign, failing which he is expected to back up the decision of the made by the state cabinet as a whole. Moving ahead, even at the state level, the chief minister is empowered to remove from office or ask the governor to dismiss a particular erring minister who is not functioning up to the mark, whose performance is met with dissatisfaction by the chief minister, or with whom the CM has a serious difference of opinion. He can be asked to resign, or alternatively he can get him dismissed by the governor. The same classification that exists in respect of ministers at the central level, the threefold classification in the form of cabinet ministers, ministers of state and deputy ministers, continues in respect of the state government as well, and it does not require any further elaboration. Cabinet ministers are those ministers who are members of the cabinet. Ministers of state, they usually are subservient, or they are lower in rank than the cabinet ministers, and deputy ministers are necessarily affiliated or attached to cabinet ministers or ministers of state at the state level. So when we speak of the state cabinet parallel to the union cabinet, it is a small body comprising of a limited subset of the state council of ministers, and it encompasses only the cabinet ministers, and it is a subset, as we've already discussed, of the council of ministers, who meet frequently to take policy decisions, to deliberate and to discern important major policy decisions of the government, which is binding equally upon the entirety of the council of ministers, and it plays a role which is in the nature of a supervisory role to the council of ministers. And even at the state level, you can expect to have a kitchen cabinet or an inner cabinet, particularly in large states wherein for political reasons the cabinet strength is expanded, particularly in coalition government based states, wherein the size of the cabinet is quite large and many people are given cabinet rank in order to accommodate the various interests of the various coalition parties. In such cases, even at the state level, a subset of the cabinet in the form of a inner cabinet or a kitchen cabinet may be formed to take quick, decisive and efficient decisions while maintaining secrecy and performing their functions effectively and efficaciously. So with this, we wind up our discussion on the state executive, the state chief minister and the council of minister, their functions, as well as the functions of the governor and what is his role, responsibilities and mandate. Until we see you in the next module, I will take leave from you. Thank you.